Kusawa nga 3 ez'okumakya Martha Nkwanzi Katanga ne Kakwanza Patricia bawala b'omugenzi Henry Katanga amanyire George ng'oni yali mukozi mu maka ga Katanga ko ne Chawiso Otayinga musawo bagasimbaganye n'omulamuzi w'ekkooti ewozesa emisango gya Naggomola Isaac Muwata okuwuliriza okusalawo kwa kkooti ku kusaba kwabwe okw'okuteebwa akakalu ka kkooti. Bano bavunaanibwa musango okutta omusuubuzi Henry Katanga. Kkooti ebadde ekubyeko obugula ab'oluganda bw'omugenzi ko n'emikwano sso n'abavunaanwa. Omulamuzi Isaac Muwata asoose kwekennenya bujulizi okuva ku njuyi zombi wabula oluvannyuma n'akkiriza bavunaanwa okuyimbulwa kakalu buli omu kabukadde bubiri ez'obuliwo.
I now turn to the merits of the application. Article 23, Sub-Article 6 of the Constitution invests this court with the power to grant or decline a bail application made before it. The same provision requires that the grant of bail should be on such terms as the court considers reasonable. Article 23, Sub-Article 6A does not give guidance on how courts are to determine the reasonableness. It has been held that the reasonableness test is the need for the court to weigh all relevant factors before granting bail to an accused person. This is the case of Foundation for Human Rights Initiative versus Attorney General. The relevant factors, in my considered view, are the likelihood of the accused attending his or her trial, the risk that if released on bail, an accused person will interfere with the witnesses, or the likelihood of committing another offense, the seriousness of the charge, and the need to protect the society against lawlessness. The court will also consider whether it is in the interest of justice to grant the application. The burden to demonstrate how prejudicial it is to the interest of justice that an accused must not be granted bail rests with the state. The first and second applicant herein referred to as Kakwanzi Patricia and Nkwanzi Martha Katanga are charged with destroying evidence contrary to Section 102 of the Penal Code Act, while the third and fourth applicants herein referred to as Otai Charles and Amanyire George are charged with the offense of being an accessory after the fact of murder under Section 393(1) of the Penal Code Act. The first applicant contended that she suffers from fluctuating severe hypertension, heart disease, chronic clinical gastritis, which requires regular access to specialized medical attention and monitoring not accessible in the women's prison. She presented a medical report from the Uganda Prisons Medical Superintendent, marked as Annexure B3. It is noted that the health condition is referred to therein are risky in prison conditions. Under Rule 14.2a of the bail guidelines, exceptional circumstances include grave illness certified by a medical officer of prison. I find that the medical report presented by the first applicant demonstrates exceptional circumstances for court's consideration. The second applicant contended that she is a nursing mother and suffers from postpartum complications. She presented evidence from Roswell Women's and Children's Hospital. In the report, it is stated that she has elevated blood pressure and suffers from postpartum pre-eclampsia. There is no doubt that postpartum complications require frequent attention. In Kagenda, Stephen and others versus Uganda, this court noted that a newly born child and a mother may require care and attention which may not be provided for in prison facilities given the circumstances where the mother is incarcerated and the child is not with her. I find that her condition constitutes an exceptional ground for court's consideration. The exceptional circumstances referred to in Rule 14.2 are not exhaustive, and the court may infer other exceptional circumstances on a case-by-case basis, depending on the circumstances of each case.
wadde nga gavumenti yali egaanya abeeyimirira abantu bano nti tebatuukana na bisaanyizo bya kkooti wabula kino kigaaniddwa omulamuzi.
The respondent argued that the applicants are jointly charged on a charge sheet with the murder count. It was their contention that the charges are grave and that the applicants may abscond if released on bail. There is no doubt that the seriousness of the offence has a clear bearing on the court when considering a bail application. Seriousness of the charge and the possible outcome of a conviction and the temptation to jump bail if released or interfere with the witness should be a key consideration. The respondent clearly informed the court that the applicants have already been committed for trial in the High Court and are only awaiting hearing of the matter. So the possibility of interfering with the witness at this stage may be speculative, as the applicants still enjoy the presumption of innocence. The question of the possibility of interfering with witnesses requires proof and not mere speculation. I will now deal with the sureties presented by the applicants. In considering the suitability of a surety, the court shall take into account the following factors: the age of the surety, work and residence, address of the surety, character and antecedents of the surety, relationship to the accused person, and any other factor as the court may deem fit. See Rule 15 of the Constitutional Bail Guidelines for Courts of Judicature Practice Directions of 2022. The first applicant presented her husband, Mwine Mukuru, her mother-in-law, Zache Marian Samananga, and her father-in-law, Kamujisha Herbert. They appeared able to make good of the recognition set by this court if the need arose. I therefore accept all the sureties presented by the first applicant. Further, I am satisfied that the relations between the applicant and their surety is such as would ensure the first applicant's appearance for trial. The second applicant presented her husband, Juvena Christian, her auntie Harriet Mchunguzi, and Bashasha Willis, a close family friend. They were all known to the second applicant, and with their close ties, they appeared substantial to guarantee the second applicant's attendance in the court. It is worth noting that the respondent did not have any specific objection to the sureties presented by the first and second applicant. The first applicant presented his brother, Opio Godfrey, his sister, Alamo Christine, his wife, Nakasuja Shamim, and his mother-in-law, Kaya Hasfa of Kenya. The respondent objected to the fourth surety of the third applicant on the ground that she did not have her original identification. They also argued that the second surety did not know where she works and invited the court to consider her demeanor. With regard to the first surety, the respondent argued that the surety, being a serving UPDF officer, did not have clearance from his superiors to stand surety and did not avoid any document such as his warrant movement card. The prosecution also argued that the fact that soldiers are deployed outside the boundaries of Uganda without prior notice makes it difficult to access him. With regard to the fourth surety of the third applicant, she presented a letter from NIRA with a verifiable NIN number which was not disputed by the respondent. The failure to avoid her original identification is explainable, and this court takes note of that fact, of the fact that the surety says that her original is lost and has undertaken a legal process to replace it. The documented proof of the letter from NIRA confirming her particulars to me is sufficient. As for the second surety for the third applicant, I have considered that her relationship with the third applicant and not her demeanor, as demeanor can be misleading given the tense atmosphere that may be associated with the court hearing of which the surety may not be accustomed. Demeanor alone cannot be enough to impugn the suitability of a surety. All factors with regard to suitability of a surety must be considered as a whole. As for the UPADF officer, there is no specific law that bars a UPADF officer from standing as a surety for an accused person. There is also no specific law that requires a UPADF officer to first seek clearance before he or she stands surety for an accused person. The most important consideration should be whether they can prevail over, control, and where necessary, compel the accused person to abide by the terms and conditions of bail. This therefore calls for persons of proven influence or authority of the accused person over the accused person, and no better person than the soldier who is a brother to the third applicant is qualified for that. Requiring the surety to first seek clearance from his superiors in order to stand surety for an accused person in court may in one way or the other impact on the accused's right to apply for bail provided for in Article 23(6)(a) of the Constitution. Therefore, upon the accused person applying for bail to choose which sureties to present to court for its consideration. Whether they are substantial or not is another matter that the court has to consider. There was no requirement for the first surety of the third applicant to seek clearance from his superiors before he agreed to stand surety for the third applicant. In respect of the fourth applicant, the respondent argued that there is no proof that he has a fixed place of abode, that the LC1 letter presented to court recommends him as a surety for someone and not proof of his residence. In response, counsel for the fourth applicant argued that the court must consider the substance of the letter, which states that the fourth applicant is a resident of Mbuya 2 parish and it should be taken by court as his place of abode.
Koti mu kukkiriza bano okuyimbulwa kidiridde okubanga emisango egibavunaanibwa ssemateeka akkiriza okugyeyimirirwa.
In the AOC letter is not fatal, as the letter states that the fourth applicant is a resident of Mbuya 2 parish and the same is contained in his affidavit in support. The sureties presented by the fourth applicant were also known to him and appear to have authority over the applicant. When interviewed by the respondent, they had knowledge of his antecedents. They were asked the name of the applicant, which was known to them. When asked what was Amanyire's mother's name, they all said the mother's name is Ada. Sharon said that the mother's name is also Ada. The one who did not know the parent's name is a friend. When asked where does Ada reside, indeed all of them answered that it was in Mbuya, with one of them on top of Mbuya giving details of the village. I do not find them as professional sureties as suggested by the respondent. Counsel for the applicants also stated that the applicants qualify for release on mandatory bail under Article 23(6)(a) of the Constitution, which provides that where an offense is triable by the High Court as well as by a subordinate court, if a person has been remanded in custody in respect of that offense for 60 days and trial has not commenced, that person shall be released on bail on such conditions as the court considers reasonable. It follows therefore that the offenses with which the applicants are charged are bailable by, are tried by the High Court and the subordinate courts. They have been on remand since 21st of November 2023, save for the second applicant who has been on remand since 10th of January 2024. For the first, second, and fourth applicants, more than 60 days have elapsed and their trial has not commenced. In such a case, the court is obliged to release the accused person on bail on such terms as it considers are reasonable, while I've already agreed with the second applicant on her condition. Lastly, the prosecution prayed for punitive terms in case the applicants are released on bail. Bail terms should not constitute punishment, and the fact that the accused persons are not convicts should be reflected in their treatment and management. I am satisfied that the applicants have made out their case for the grant of bail. I shall accordingly grant them bail on the following terms. Each of them shall make cash deposit of 2 million shillings, and each of their sureties will execute a bond of 20 million, non-cash bond of 20 million. Each of the accused applicants shall not travel outside of the country without the express permission of court, and if any of them is holding an invalid passport, then they shall be placed in the custody of the court. Each applicant shall report to the Deputy Registrar of the Criminal Division every first Monday of each month, beginning on the 4th day of March 2024. I so order.
Oluvannyuma lw'ensala y'omulamuzi, oludda oluwawaabirwa lulumirizza oludda oluwaabi okusisinkana omu ku bavunaana George amanyire mu kkomera Kigo nga bagezaako okumumatiza okukkiriza omusango guno azzibwe ku ludda oluwaabi ng'omujulizi.
Some officers from the office of the DPP and police be approaching him. My Lord, we find this most unconventional and totally unacceptable and much of that. Agents of the state. Sorry, my Lord. Okay. Right. I'm saying, my Lord, that we have a housekeeping matter which we want to bring to the attention of the court. My Lord, that is that the state has on 3 different occasions approached our client in Kigo prison, talked to him in an attempt to make him retract, change or vary the statements which he made at police. My Lord, this is an issue which has left our client uncomfortable for the number of days he has been in Kigo prison.
Uncomfortable?
Yes, very uncomfortable. But why would some officers from the office of the DPP and police be approaching him? The state informed the court that investigations are over, they were committed for trial, and is now in the hands of the court, not anymore in the hands of police or in the hands of DPP. My Lord, our client is here, and if the court wishes to find out more from him, you can actually. So we thought, my Lord, that we should bring this matter to court, that these attempts, that's what we wanted to bring to the attention of court, my Lord.
Envunza eyingiridde ekitongole ekiwaabi ekya DPP eyetaaga okutundula n'ekikwanso ekisingayo obunene. Nti kakati DPP atandise oluvannyuma lw'okukyajinga abantu, atandise ate okubagoberera mu makomera, ate n'afuuka investigator n'atandika bagamba bakyuse statement zaabwe zibakola ku poliisi. Ekintu ekyo kyakusaalirwa nnyo mu mateeka tekikkirizibwa ne mu buntu obulamu tekikkirizibwa. Wotandikira okukyajinga omuntu kitegeeza oyina obujulizi obumulumika. Ate lwaki oyita emabega ate n'otandika okumusanga mu kkomera n'omugamba kyusa bye wayogera ku poliisi nkuggyeko ate omusango nguteeke ku banno olume banno. Ekyo kintu kikyamu kikyamu nnyo tukivumirira ne sekuvumirira yenna bw'oba toyina aba DPP bakagenda oyo omusibe basooka ne bamugja eruzira we yali asibiddwa ne banne ne bamutwala ekigo ne batandika okumubuzaabuza omuvubuka Shamba Boy tamanyi luzungu bamuvisitinga muwaganya yakulembera tiimu emuvisitinga bagamba akyuse statement akole statement kati endala ng'ate aluma banne ng'ate olede bamukyajinga dda era n'olaba baali balwanyisa nnyo bail application y'oyo omuvubuka gye beesibako yekka golooza lwaki gwe baali balwanyisa nga baagala asigaleyo basigale okumupromisinga bamutwalira obusente bamulimbalimba bamutwalira baloya abalala ate amateeka tegakukkiriza kusinkana client wange nga siriiwo ekyo ekintu kivumirira ne sekuvumira eyo envunza DPP tumusaba anoonye ekikwanso ekinene ekisingayo obunene atundule envunza kawukumi atandise okumuyingirira mu ofisi ye.
Oluvannyuma lw'abaana okuyimbulwa kati oludda oluvunaanwa lutegeezezza nti lwakusabira nnamwandu w'omugenzi ng'ono ye Mole Katanga okuteebwa ku kakalu ka kkooti.
Mpulira bulungi nti kidda obudde butuuse obwedda wabaddewo okwetooloola kungi tulinga enkumbi etajja muyini nga tulimu ebyo ebintu bya bbeire emirundi 15 tunoonya bbeire eri awo efuuse mataganyana naye olwaleero erabise obwenkanya bulabise so ekyo tusanyuse nakyo ziri okay conditions ziri okay zisoboka mujjukiranga omusajja agamba mbu basetinge miliyoni 10 n'ebyapa by'amataka omuntu gw'okyajinga nansi ebyapa by'amataka abijjewo n'obukadde 10 omuntu gw'okyajinga Shamba Boy obukadde 10 n'ebyapa abijjewo ekitegeeza omwavu mu Uganda taafunenga bbeiro olw'okuba talina byapa bya ttaka n'obukadde 10 obwo bwewusa oyo ye kawukumi n'envunza zenjogerako eziyingidde mu DPP ze balina okutundula. Tugenda ku applyingira Madam Mole bail tugenda kujja applyinga olwaleero benkya tugenda kujja applyinga. Tuli redde bana abantu tebalina bujulizi tewaliyo bujulizi omusango bagufutyanka omusajja yetta bone batandika okufutanka ebintu tewali bujulizi tuli redde n'okuguulira n'enkya waalu singa bali redde.
Omusuubuzi Henry Katanga yattibwa mu maka ge Mbuya mu ggombolola y'e Nakawa ng'ennaku z'omwezi 2 omwezi ogw'Ekkumi n'ogumu omwaka gwa 2023.